72nd District Court Mark Trial now in session. Honorable Judge Elwood Brown presiding.
Good morning. Be seated. Well, first of all, I want to take a few moments just to welcome everyone to this 4th annual mock trial tournament event. This is the first of the competitions this morning, in this courtroom anyway. And I'm going to start first by recognizing the judges here and the bailiff. As you probably recognize, our bailiff is our newly elected sheriff, Tim Donnellan, and we certainly appreciate him volunteering his time to be here as well. The lawyers in the St. Clair County Bar Association have sponsored this event and are volunteering their time to participate here, not only as coaches with the various teams, but also as judges. So at this time, I want to ask the various judges to stand up and give you a brief summary of who they are, and I'll start with Mona Armstrong.
Good morning. My name is Mona Armstrong, and I'm a senior assistant prosecutor here in St. Clair County. I've been practicing for 15 years, and the vast majority of that has been as a trial lawyer in the prosecutor's office. So I can relate a lot to what you're all doing here today, and I'm very excited to see what you're going to do.
Ms. Armstrong, right next to her is Attorney Greg Stremmers.
Good morning, everyone. Congratulations on being here. I know it's a hard work. I've been a trial lawyer in town here for 15 years, so I know what you've been going through working up this case. So good luck today.
And Cynthia Lane.
Hi, I'm Cynthia Lane. I am a lawyer in private practice. I've been doing trial work for going on 29 years. This is my 29th year in the practice of law, and this is my 2nd year as a judge in this program, and my 4th year participating in this program. Good luck to all of you.
And in the back row, we have David Keys.
Good morning, my name is David Keys. I am a partner in Kelly Whipplezick & Keys. I am a civil litigator, and good luck to everyone.
And Mark Davidson.
Good morning, I'm Mark Davidson. Also in private practice. I'm with the firm of Hill Devendorf here in Port Huron. Let's see, I'm in 33 years. I've been practicing a lot of litigation too, and I've been a judge since the program started, so I think this is 4th or 5th, whatever year it is. And I already see a couple of faces that have been here before, so give it a good shot and enjoy yourselves.
As Sheriff Donnellan indicated, I'm Judge Elwood Brown, and I am a sitting judge in this county. I'm a probate judge. But do just basically family court. I handle all the abuse and neglect cases and the juvenile delinquency cases and a third of the divorces that happen in the county. Prior to that, I was a trial lawyer in the St. Clair County Prosecutor's Office. I was the elected prosecutor for 7 years and an assistant for 10 years before that. This is my 30th year as a lawyer, my 10th year as a judge. I have spent my entire career pretty much in the courtroom. So it's a pleasure to see all of you here and participating in this event and showing some interest in not only the legal procedures that you're learning, but also in the theatrical performances that you're doing. And I recognize that that's basically what a trial lawyer does, is they're also not, they don't just know the law, but they perform before a jury. And it can oftentimes be entertaining. And at this time, I'm going to ask the respective lawyers to place their appearances on the record, and we'll begin with the plaintiff.
My name is Emily Tyson, and I will be representing Sydney Young.
My name is Samantha Shields, and I will be representing Sydney Young.
My name is Ashley Unfair, and I will be representing Sydney Young.
Defense?
My name is Henry Herbert, and I will be representing Riley Gardner.
My name is Courtney Weiss, and I will be representing Riley Gardner. My name is Tabitha Stewart, and I will be representing Riley Gardner.
All right. The plaintiff may make their opening statement.
Good morning, ladies ladies and gentlemen of the jury. My name is Samantha Shields, and I am here today on behalf of my client, Sydney Young. After illustrating the tragic events that occurred on the morning of May 12, 2007, it will become clear that the defendant, Riley Gardner's negligence, was the direct cause of Miss Young's permanent injuries. Negligence is the failure to use ordinary care. Ordinary care is the care a reasonable person would have used under circumstances of a situation. After the evidence is presented today, it will become clear that the evidence and that the defendant did not exercise ordinary care on the night. It all innocently began when Sydney attended a party to celebrate her high school's baseball team's championship win. With no intention of driving that night, Sydney had had a few drinks. Around midnight, Sydney was offered a ride by the defendant to go and get something to eat. While the defendant was driving, he or she had received a few text messages and replied numerous times. Texting while driving is not the only irresponsible thing that the defendant did that night. He or she was also speeding, as Peyton Lancaster, an expert accident reconstructionist, concluded. Also, Evan Simpson, an unbiased witness to the accident, said it looked as if the defendant was going over the speed limit. Driving recklessly is nothing new for the defendant. She has already received 2 speeding tickets and even admits to having a reputation for texting while driving. Phone records will clearly show that the text messages were sent exactly during the time of the accident from the defendant's phone. Not only did the defendant fail to operate her vehicle with a duty of care to her passengers, she violated 2 local laws by reading and writing text messages while driving and going over the speed limit. It is a tragedy that others have to suffer for one woman's careless mistakes. Because of the defendant's poor choices that night, Sydney has to live with these consequences for the rest of her life. As a direct result of the defendant's negligence that night, Sydney had to surgically have a metal rod and pins put into one of her legs. Eventually, Sydney will have to have this leg replaced. 3 of Sydney's ribs were broken, making it hard for Sydney to simply breathe. These are not all the damages Sydney has suffered. Sydney is blessed with an amazing artistic ability. She has won multiple art contests, and her dream was to make a career of this passion. However, Sydney is right-handed, and due to the crash, her right hand is now completely mangled. She can hardly move her fingers, and painting and drawing are now completely out of the question. Due to the injuries in her legs and lower back, Sydney is no longer able to sit for long periods of time. Yet another factor holding her back from being an artist. Sydney also suffers from frequent headaches that medicine simply cannot cure. At the end of this trial, you will deliberate and make a decision that will greatly affect somebody's life. I ask you please to consider my client's future plans, all of her life-altering injuries, all because of the careless decisions that the defendant made. Please hold the defendant responsible for her recklessness and hoping that the defendant will think twice before ruining another individual's life. Thank you.
Does the defense wish to give their opening statement now or reserve it till later?
Yes, Your Honor. We will do it now.
Go ahead.
Your Honor, do I have permission to move away from the podium?
You can move as long as you're by a microphone so we can pick you up.
Okay. May it please the court. Ladies and gentlemen of the jury, Your Honor, I am Courtney Weiss, here with my co-counsel, Henry Herber and Tabitha Stewart. We are here on behalf of Riley Gardner, a young lady who has been wrongfully accused by someone whom she thought to be her friend, Miss Sydney Young. We are not here to downplay the injuries Sydney received on the night of the accident. We are here to show you that she is more than 51% negligent and responsible for the injuries that she received that night. The first witness we will bring to the stand is Adrian Knight, a supervising officer with the City of Clearwater Superior's Police Department. She arrived at the scene of the accident around 10 minutes after it occurred. She noticed that there was something wrong with the tire, which could have been a cause of the accident. She took blood alcohol tests on both Riley Gardner and Sydney Young. The results came back and proved that Riley had not been drinking that night whatsoever, while Sydney had a .09 level of intoxication the entire night. The next witness we will bring to the stand is Alex Williams. Alex is a key witness because she was in the car with both Riley and Sydney the whole time and witnessed everything that happened that night. Alex too noticed that there was something wrong with the tire, which could have led to the accident. Alex witnessed Riley give the phone to Sydney before the accident occurred, proving that Riley was not texting while she was driving. or at the time of the accident. She also witnessed Sydney take off her seatbelt before the accident and never rebuckled it. The third witness we will bring to the stand is Riley Gardner. Riley is a very responsible young lady. She proved so on the night of the accident because she did not drink it all at the party. She has seen firsthand what alcohol can do to a family, and we will prove that. She also told everybody in the truck to buckle up. She gave the phone to Sydney because she knew that she should not be texting while she was driving because it was irresponsible. After we bring all three witnesses to the stand, we know that you will see that Riley was not negligent that night and in fact was very responsible, and that Sydney is more than 51% negligent and responsible for her own injuries, and Riley is just a pawn in her game. Thank you.
Thank you. All right, the plaintiff may call their first witness.
I would like to call Miss Peyton Lancaster to the stand.
Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated, please.
Could you please state your name, spelling your last for the record?
Peyton Lancaster, Lancaster.
Miss Lancaster, what is your occupation?
I'm an accident reconstructionist.
Do you have any form of certification?
Yes, I'm certified through the Accredited Coalition for the Reconstruction of Traffic Accidents.
How did you gain your certification?
I took an examination that consisted of both a written and practical portion.
Did you have any problems with your exam?
Yes, I had minor difficulty passing the practical portion the first 2 times, but I did earn my certification.
Are you required to renew your membership at all?
Yes, every 5 years.
Does testifying in court help with that process?
It does.
Is that why you're here today?
Absolutely not.
Have you done anything notable that is related to your profession?
Yes, 3 years ago I was a guest author in Wrecked.
What is Wrecked?
It's a professional journal concerning accident reconstruction.
And have you ever testified before?
No, I haven't, but I have given my deposition 3 times.
And are you being paid for your services?
I am $250 per hour, but everyone here is being paid.
When were you contacted about this case?
Within 2 days of the accident?
Did you visit the accident scene?
No, I didn't.
Why not?
Because it had rained between the time of the accident and when I was contacted, so I felt that my time was better spent elsewhere.
What did you do instead?
I reviewed the accident reports as well as witness statements and measurements taken by the Clearwater Police Department.
And where did the accident occur?
It happened on Wellscape Parkway, approximately 1 mile south of the intersection with Fisk Avenue.
Did you determine the speed of the vehicle?
Yes, I did.
How is this determined?
By using the skid and speed formula?
Is it different if the vehicle was still moving?
Yes, if the vehicle was still moving at the times the brake were first applied, it would only yield the minimum original speed.
Was this the case for the accident in question?
It was.
How did you determine that?
Well, the vehicle was definitely moving at the time of the accident because of the skid marks on the roadway, as well as the muddy treads in the grass and the scuff marks on the curve.
Did anybody help you with this case?
Yes, I sent a colleague that I work closely with to examine this scene.
What did he do?
He gathered measurements and other important information.
Did he measure anything specifically?
Yes, the skid marks on the roadway.
And how long did he find them to be?
Approximately 73 feet in length.
Was there anything else notable about them?
Yes, the skid marks were far more prevalent at the onset than they were at the end.
And how did you use this information?
To determine the speed of Riley Gardner's vehicle.
And how fast was the vehicle traveling?
Approximately 43 miles per hour.
And what is the speed limit on Wellscape Parkway?
I believe it's 35.
What is your conclusion?
That it's more likely than not the defendant was indeed speeding at the time of the accident.
Was there anything wrong with the vehicle?
Yes, the right front tire was flat.
Was the tire flat at the time of the crash?
No, in my expert opinion, the tire went flat after the accident occurred.
How do you believe the tire went flat?
Due to the strong impact against the curb.
Is it possible that it went flat in another manner?
Well, it's highly unlikely, but it could have been punctured by something in the roadway or in the grass.
Why is this fact uncertain?
Because the local law enforcement didn't see fit to test the tire or preserve it for later testing by a third party.
Are you aware that texting is believed to have played a part in the accident?
Yes, I am.
And can this at all be determined?
It can't, but I do agree that the time of the text messages coincide with the time of the accident.
And Miss Lancaster, do you have any previous knowledge about texting and driving?
I do. I'm currently conducting a study involving teenagers and the effects of text messaging while driving.
What did you find in your study?
That text messaging, specifically sending a text message, seriously impairs the driver's ability to respond to critical driving measures.
Thank you. No further questions.
Cross-examination?
Miss Lancaster, it has been stated that you took your ACRTA test 3 times. Is this right?
Yes.
Isn't it also true that the ACRTA restricts its applicants to taking this test 3 times?
It does.
And this was the practical portion of your test where you answer questions about a staged collision, wasn't it?
Yes.
Is it also true that you almost always testify for the plaintiff in civil cases because you have friends within plaintiff firms?
I suppose I would say that.
Is it also true that you're being paid $250 per hour today?
Yes, but you're being paid as well.
Miss Lancaster, you have never actually seen the site of the accident yourself, have you?
No, but I have seen photographs.
You did send an engineer to observe the site, correct?
Yes.
Now, you said that it would have been a waste of time for you to observe the site yourself because it had rained after the accident, yes?
No, I don't believe it was a waste of time. I just felt my time was better spent elsewhere.
Well, Miss Lancaster, the engineer was able to obtain evidence, wasn't he?
Yes.
Miss Lancaster, you also stated that although the speed of a vehicle can be determined by the length of its skid marks, the grade of the road and the condition of the tires must also be considered.
True.
Right? You said that you had come to the conclusion that Riley was speeding at the time of the accident.
That she was more likely to be speeding.
Well, Miss Lancaster, you've never seen the tires that are in question, have you?
No, I haven't.
Well then, Miss Lancaster, it seems to me that the calculations might not be accurate since you've never seen the grade of the road or the condition of the tires, right?
Well, I haven't seen the condition of the tire, but I am aware of the grade of the road.
Miss Lancaster, you said that you thought the tire was punctured before the accident, but it could have flattened upon impact, yes?
It could have, but it's very unlikely.
And you have not seen the tires to prove otherwise, have you?
No, no one has. The officer didn't see fit to preserve the tire for testing.
Miss Lancaster, another point in question is whether or not at the time of the accident my client, Riley Gardner, was texting. Can you prove that he was texting?
No, I can't, but the times do coincide.
But you still can't prove that she was texting, can you?
No, I can't.
Thank you. No further questions.
Redirect.
Yes, Your Honor. Did you pass your accreditation exam?
Yes, I did.
And in civil cases, you do generally testify for the plaintiff?
Yes, it's true.
And why did you not visit the scene of the site yourself?
Because my time was much better spent on the accident reports as well as the witness statements.
Your colleague that you sent there, was the information that he gathered something that was necessary for you to gather yourself?
No, it wasn't. Anyone could have gathered that information as seen by the officer who also gathered the same. It wasn't necessary for an expert to do that.
And what is your opinion as to the reason for the flat tire?
That it became flat due to the strong impact against the curb.
And when you determine the speed of the vehicle, what all information do you use?
Well, you use the length of the skid marks, and it is helpful to know the condition of the tires as well as the grade of the road.
Did you take all of those factors into consideration?
I took all of the available factors into consideration.
What wasn't available?
The tire, because law enforcement didn't preserve it or test it themselves, so this information was impossible to have.
Thank you.
All right, you may step down. Next witness.
And the prosecution, or plaintiff calls Cindy Young to the stand.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated, please.
Hi, can you please state your name, spell your last name for the record?
Sydney Young, Y-O-U-N-G.
What's your occupation, Miss Young?
I'm a student,
And how old are you?
18.
And where are you living?
I live with my parents in Clearwater.
Why are you living with your parents?
Because of my injuries, I can't take care of myself.
Let's talk about these injuries. How did you get them?
From the car crash with Riley.
And let's talk about this crash now. What happened before it?
I was at a party.
And why were you at this party?
It was a celebration of some sort. I'm not really sure what. Maybe sports. I'm just more of an artist.
Okay, and while you were at the party, did you do anything?
I had a few drinks.
And did you decide to leave it all this evening?
Yeah, I heard some people were going to get some food, so I was feeling kind of sick and I decided to go with them.
So who did you leave with?
Riley and Alex.
And who was the driver?
Riley was.
And where were you sitting in the vehicle?
I was in the passenger seat.
And while you were sitting in this passenger seat, did you have any feelings at all?
I was really nervous and, excuse me, really uncomfortable because Riley was texting and she was felt like she was speeding too.
So in the process of Riley texting and speeding, she managed to crash the car, right?
Yeah.
And did you receive any injuries from this?
Yeah, my hand was mangled, my right hand, and my arm was kind of hurt. And I had 3 broken ribs, and I got a metal rod placed in my leg.
Thank you, Your Honor. No further questions.
Cross-examination.
So, Miss Young, you were at the same party as Riley Gardner the night of the accident, correct?
Yes, I was.
And you didn't even know what the party was for, right?
Right.
You just went. And she was the one who suggested that you needed something to eat, right?
I was feeling kind of sick.
Because you were drunk, right?
I guess you could say that.
Do you know about how much you had to drink that night?
Not really.
Are you aware of your statement?
Yeah, I think so.
In your statement, I believe you stated that you had about 5 beers, correct?
Oh, I guess so, yeah. I don't recall.
How old are you?
18.
Do you know what the legal drinking age is?
21.
Okay. So you know the legal drinking age, but you decide to drink anyway.
Yeah.
Who did you get in the car with that night?
Riley and Alex.
About how long have you known them?
Not very long, but Riley and I were becoming a little bit closer.
About how long have you known Riley?
I'm not really sure. Not very long.
In your statement, didn't you say you've known her about a month?
Yeah, I guess I must have forgotten.
Thank you. Did you ask Riley if she had been drinking that night?
No, I didn't.
Did you ever suspect she was drinking at any time?
I hadn't, but I'd heard after that she had been.
So you didn't know if she was under the influence or not?
No, I didn't.
So that night you were drunk, riding in a car with people that you don't really know that well, who may or may not have been under the influence. Correct?
Yes.
Also, you said in your statement that you relive and remember every single detail that happened that night, every day, right?
Yes, I do. Most of them except for the parts that I can't remember.
That's exactly what I was going to say. How can you remember every detail from that night correctly when you were intoxicated the entire time?
I remember the details that are in my mind, the memories that I can recall.
But you don't remember the whole night?
No.
And some
After
parts
the
were
crash, I
blurry and
passed
fuzzy,
out.
correct?
Yes.
Objection, Your Honor. She's badgering my witness.
I am just trying to get out the point that she was drinking that night and cannot remember things correctly. I'm not meaning to badger her.
Objection's overruled. I don't see it as badgering. However, you are talking over the witness, and you need to let her answer before you ask the next question.
Sorry, Your Honor.
Thank you, Your Honor.
So you do admit that some parts of the night you could remember wrong because you were
I
drunk?
guess you could say that.
All right, no further questions. Thank you.
Redirect.
Ms. Young, you have admitted that you were drinking that night, but
Yeah.
weren't you taking responsibility by not driving?
Yes.
And did you plan at all that night to actually be driving?
No, I did not want to drive at all because I knew I'd be drinking.
And because your thoughts were that Riley was not drinking, you got into the car with her,
Yes.
correct? Thank you, Your Honor. No further questions.
Okay. Plaintiff may call their next witness, and you may step down.
Thank you.
Your Honor, I would like to call an Evan Simpson to the stand, please.
Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated, please.
Good morning.
Morning.
Please state your name and spell your last name for the records.
Evan Simpson, Simpson.
Are you currently employed, Evan?
Yes, I am. I work at the laundry at the Madison County Medical Center, and on the weekends, I work at my grandmother's restaurant, the Silver Spoon.
And what were you doing the night of May 11th, 2007?
That night, I was over at my friend Joe's house, and we decided to watch old reruns of American Idol. And at that time, after we were watching those for a while, we decided to have some fun and get some lottery tickets.
Did you leave Joe's house at any point that night?
Yes, we did. We left to get the lottery tickets.
And where did you get these lottery tickets?
We got them at the service station on Pitts Avenue East.
Did you come to any intersections on the way there?
Yes, we did. And at the intersection, I saw a car.
Do you know the speed limit on Wells Gate?
Yes, it is. It's 35 in that section.
Other than the speed, could you see that the car was speeding at all?
Yes, to me, it looked like it was going faster than the recommended speed.
Did you notice anything else about that car?
Yes, I noticed a faint green glow as if, like, you use a cell phone in the nighttime.
Evan,
And
how well could you see?
I can see very well. I just had laser eye surgery, and I don't have to wear contacts or glasses.
Did you see anything else concerning the car that night?
Yes, the driver's head, when I looked at it, the driver's head was down, and I never seen it go up to look at the road.
Evan, have you been to court before?
Yes, I have.
And how was that experience?
It's very crippling because the people who cross you, they try to twist your words around to get what they want.
Thank you. No further questions, Your Honor.
Cross-examination.
What were you doing at the scene of the accident?
I was in my friend's car looking in the mirror.
But you were near the scene of the accident. Correct.
Yes.
So you noticed Riley in the car accident when you walked out of the lottery place?
We got the tickets I'm sorry. I seen the crash. I was in the car.
Okay. Have you ever been in trouble with the law before?
Yes, I have.
And that was for?
It was for stealing money from my grandmother's restaurant, but it was a very long time ago.
But you did get in trouble for the law, from the law
Yes, I
before.
did.
Okay. So what you're saying is you embezzled money from your grandmother, correct?
Yes. It was a very long time ago, though, and I've learned my lesson.
But you did embezzle money.
Yes.
Okay. How much money was that?
More than $1,000.
Okay. Okay. Your Honor, may I approach the bench to show you what has been marked as Exhibit 3?
Don't need to approach the bench. What's your purpose of offering the exhibit?
I'm just trying to prove how much money he embezzled, to prove his credibility in this case.
Does the plaintiff have any position with regard to this request?
Your Honor, no objections.
All right, you may approach. Okay, thank you. I'll give it back to you.
Yeah. Okay. Can I approach the witness
For what purpose?
to show him the document?
And what would be the purpose of showing them the document?
For him to identify what this document is?
You may approach the witness.
Thank you.
Now, Evan, can you identify the document?
Yes, this is a judgment of my conviction.
Okay. On the document, does it say correctly how much money you embezzled?
Yes, 1 second, let me find it.
Shouldn't you know? I mean, you said it was a long time ago.
Yeah,
but
it
you
was
did
a long
admit
time
to
ago.
embezzling money.
Objection, Your Honor. The lawyer did not admit this exhibit into evidence.
I just did. This is what I'm doing
Wait a
right
minute,
now.
wait a minute. When you respond to an objection, you have to talk to the court, not to the other party. So I'll ask for your response now.
I am admitting it into evidence right now.
The objection is sustained.
$1,935.
Now, wait a minute, there's an objection that's been sustained.
Sorry.
The proper foundation hasn't been laid.
So your name is on this document, correct?
Yes.
So you have been in trouble with the law and you have embezzled money.
Yes, I have.
Okay.
A long time ago, though.
You still did it though, correct?
Yes.
Okay. Thank you. Now, you said that you noticed that the car was moving fast,
Yes, it seemed like it was moving very fast to me over the speed limit.
and you noticed that from an intersection, correct?
Yes.
Now, how fast did you think the car was moving?
Over 35.
Okay. And you said the speed limit was?
35.
So then he wasn't speeding.
I said over 35. It looked to me as if he was going over 35, which the speed limit is 35.
Okay, but you can't accurately judge how fast the car was moving.
No, I cannot.
Okay. Have you judged other cars' speed before?
No, but I am kind of a backseat driver.
So you have no prior history of judging car speeds.
No, I guess not.
So then you can't accurately judge this car's speed, correct?
No. But to me, in my opinion,
But you can't, correct?
No, I cannot.
Okay. And you noticed that the car was moving fast on a sloped road? I mean,
Yes.
so you didn't take into account that the road was sloped?
No, as you said to me before, that I can't accurately account for the speed that they were going.
Okay. And as for the glow in the car, do you own a car, Mr.
Yes, I
Evan?
do.
You do?
Mhm.
And does it have a dashboard or like an instrument panel?
Yes, it does.
Now, could that have been the glow that you saw that night?
I mean, it could have been, but I personally think
It
that it
could
was a
have
cell
been, though.
phone. Yes, I guess it's possible, but not very likely.
Well, I mean, you said that you thought the car was going fast, and if the car is moving fast, you couldn't have accurately seen a silhouette of a cell phone, correct?
No, I never said I seen a cell phone. I seen a greenish glow in the car.
But you're implying that it was a cell phone.
Yes. That's what I think it was.
Right, but if the car was moving fast, you couldn't have accurately seen what this object could have been.
I have better than 20/20 vision.
Argumentative.
Sustained.
Thank you.
Okay. So you're not sure that it was a cell phone or any other object that
No.
the driver had in his possession?
No, I can't be 100% positive.
Okay. Thank you.
Yes,
Redirect.
please. Evan, do you know any of the people involved in the crash?
No, I do not.
Do you personally care who wins or loses?
No, I'm pretty unbiased in this case.
No further questions, Your Honor.
All right, you may step down. Does the plaintiff have any further witnesses?
No further witnesses, Your Honor.
You're resting?
Yes, sir.
All right. Defense, do you wish to call witnesses?
Yes, we do.
Go ahead.
Can I call Yes, Your Honor. Can I call Adrian Knight to the stand?
Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated, please.
Please state your name.
Adrian Knight,
Spell Knight, please.
K-N-I-G-H-T.
Okay. What is your occupation?
I'm a supervising officer for Clearwater City's Police Department.
How long have you been a supervising officer?
Long while.
What did you see at the accident scene?
I saw a car that was wrapped around a telephone pole, and then I saw the witnesses, the people in the car.
Did you write up a police report?
Yes, I did.
Okay. Your Honor, may I approach the bench to show you what has been marked as Exhibit 1A, which is the police report?
May I see the report, please? Thank you. No objections, Your Honor.
All right, you may approach.
May I approach the witness to give her the police report?
For what purpose?
To show what time the accident took place?
Any objection?
No objections, Your Honor.
Go ahead.
Now, Adrian Knight, you wrote this police report, correct?
Yes.
So can you find me on there what time the accident had
Objection,
occurred?
Your Honor. The exhibit has not been admitted into evidence, and it's my understanding that you can't talk about it until it is.
Response?
Sorry, Your Honor. Can you identify the document?
It's a traffic report.
Okay.
Just for the record, the objection is sustained. Go ahead.
And you wrote this traffic report, correct?
Yes.
So you completely know what this document is?
Yes.
Okay. I move that it is subjected into evidence right now.
No objections.
Okay.
All right. Based on the stipulation, it'll be admitted.
Okay. Now then, since you wrote this up, can you tell me what time the accident took place?
1:13 a.m.
Okay. Did you think that texting could have been a factor in the accident?
No, I don't think so.
No, you don't think so?
No.
Okay. Did you get the phone records from Riley's phone?
Yes, I did.
Okay. And did they show that there was texting at the time before the accident?
Yes, before the accident, yes.
Like minutes before or
Yeah,
hours?
a few minutes before.
Okay. And did you notice anything different about the text closer to the time of the accident?
Yes, there was evidence that it was written by a different author. The voice of the text messaging was different than the earlier ones.
Okay. Your Honor, may I approach the bench to submit the text messages into evidence?
Are you making a motion to admit them?
Yes.
Your response?
I don't believe the proper foundation has been laid in order for them to be admitted.
Well, based on the rules of the procedure, it's been stipulated to as for admissibility, so it can be admitted, and I'll allow the admission.
Okay. May I approach the witness?
Go ahead.
Can you identify this document?
It's the texting from Riley's phone. The text.
That you received, right?
Yes, that I received.
So you've looked over this document, correct?
Mm-hmm.
Is that a yes?
Yes, sorry, yes.
Okay.
Now, on page 3, the last text message before the accident, can you tell me what it says?
Can't believe you're acting like this. I love you. Hope you're happy. Page 3,
Yeah,
sorry.
page 3.
No, I'm happier with Sydney. Leave me alone, please. Good night. Bye.
Okay. Now, can you read the text message just before that? Exactly, letter for letter, what it is.
Come to shack?
Are those letters abbreviated?
Yes.
Okay.
CMN2SHAK.
Now, the text message after that is not abbreviated, correct?
Correct.
So, do you believe that somebody else wrote those text messages?
Yes, I do.
And you think this because?
Because it's so much different from the other ones. All the others were abbreviated, but that one was not.
Okay. Now, did you draw up a diagram
Yes,
of
I
the
did.
accident scene?
Yes, I did.
Did? Okay. Your Honor, I would like to submit, or have a motion to introduce the diagram of the accident.
No objections.
All right,
Do I have to show you?
the diagram's on the board.
Okay. Now, do you believe the car was speeding according to this diagram?
No, actually, I believe it was 5 miles under the speed limit
And you figured this out?
by the skid marks.
Okay. Now, with the skid marks, how did you figure that out?
Measuring them.
And did you apply other factors to the equation, like
Yes,
the weather?
the roads and the weather and if he was texting or not. And
Okay. So, just to let it be clear, she thinks it is 5 miles under the speed limit,
yes.
which is different from what Peyton said. Did you see Riley Gardner at the scene?
Yes, I did.
Would you say there was any impairment to Riley's senses?
No, not at all. She seemed perfectly fine.
So she was just a normal person even though she was in a car crash?
Yes.
Was she attentive to you?
Yes.
Okay. Did you take a blood alcohol test?
I administered a blood alcohol test, yes.
And the results were?
There was no alcohol in her system at all.
Okay. So there would have been no impairment?
Exactly.
Okay. Did you notice Cindy Young at the accident scene?
Yes.
And did you notice anything about her?
She seemed a little out of it. She seemed kind of drunk and tipsy.
Okay. Did you order a blood alcohol test of her?
Yes, I did.
And the results were?
It was .09.
So she was heavily intoxicated?
Yes.
Correct? And that's over the legal limit,
limit.
correct?
Yep.
Isn't it also a law that you cannot drink under the age of 21?
Correct.
Okay. And how old did you say Cindy Young was?
18.
Okay. And is it true that you took a class in accident reconstruction?
Yes, I did.
So, in your professional opinion, did you suspect that the road could have played a role in the accident?
No, I don't think the road played a role in the accident at all.
And you think this because
Because there was nothing wrong with the road.
there were no obstructions or anything on the road?
No,
correct?
no obstructions or anything.
Objection, Your Honor. The witness is not an expert in accident reconstruction. She is an expert in accident investigation.
Your Honor, she is a head police officer, and her thing is in investigation. So in order to investigate a crime, you have to know all the aspects. So I think she's more than capable of determining where the car was at the time of the accident.
It's been stipulated, too, that the witness is an expert in accident investigation, not accident reconstruction. The objection is sustained. You can lay a foundation for questions with regard to something outside that stipulated expertise if you wish, but you haven't established a proper foundation for that.
Okay. Okay, so in your experience as a lead police officer who has taken a highly desired course in accident investigation, do you believe that, in your professional opinion, that Riley was speeding?
No, I do not.
And you believe this because?
Because of the skid marks and the way that the road was.
So, you said there were skid marks, so do you believe that the driver was aware that there was a problem on the road?
Yes, it looked like she was trying to stop before the accident happened.
Okay. And it is true that you said that the weather was not a factor in the accident, correct?
Correct.
Objection, Your Honor. Leading question.
Sustained.
Didn't you say in your statement that the weather was not a factor in the accident?
Correct.
So if speed, weather, and the driver's senses weren't the cause of the accident in your professional opinion, what do you believe was the cause based on the evidence you collected?
Based on the evidence that I had collected, I didn't see a cause of the accident.
Are there any other factors of the accident that you think could have been a cause from what you collected?
No,
So you have no idea why this accident took place?
no, I don't.
Thank you.
Cross-examination?
You are a supervising officer for the Clearwater Police Department, correct?
Correct.
And isn't it true that you only had a 5-day training session in accident reconstruction?
Yes, but I do plan on taking a course on it.
Objection, Your Honor. It's irrelevant whether or not how long the class was.
Your Honor, I'm just trying to say that she has more, her expertise or knowledge about accident reconstruction is minimal compared to her training as a police officer.
It's relevant as to the credibility of the witness's opinion. Overruled.
Wouldn't you say that your training as an accident reconstructionist is not sufficient compared to your training as a police officer?
My training as a police officer is longer, if that's what you're referring to.
Yes. And didn't you say that you wanted to become a certified accident reconstructionist because you could then, quote, pick up a lot of extra work as a professional witness?
Yes.
And it was your job to investigate the accident and prepare the report for this case, correct?
Correct.
You consider yourself an expert in accident investigation, right?
Yes.
Did you collect all of the evidence pertaining to the accident in question?
Yes, I did.
And you interviewed all of those who were involved in the accident, correct?
Yes.
Would you say that you performed a thorough investigation of this accident?
I believe I did, yes.
And at what time did the accident occur?
About 1:13 a.m.
According to your statement, what time did you say the accident occurred?
1:10 a.m.
Your Honor, may I please approach the witness with her statement?
For what purpose, please?
For the purpose of her reading the time of the accident that she stated.
Is this for impeachment?
Yes.
Any objection?
Yes, Your Honor. According to the text messages, the last text message was sent at 1:11 and 59 seconds. There's no way the accident could have occurred before
Well,
that?
that's an argument. I'm asking if, as it relates to the request to approach the witness to show this, any objection to that?
No, I do not.
You may.
Thank you. Could you please read on lines 40 and 41 this sentence?
Okay. I was called out loud?
Yes, please.
Okay. I was called to examine the scene and evidence from a wreck that occurred at approximately 1:30 a.m. on May 12, 2007 on Wells Gate Parkway in Madison County, Superior.
Thank you. And at what time did you arrive at the scene?
10 minutes after.
Your Honor, I'd like to approach the witness with what has already been admitted as Exhibit 1,
And which exhibit is that?
the accident report that she filled out.
Any objection?
No, Your Honor, but can I see it?
Go ahead.
Now, according to this report that you filled out, what time did the accident occur? It's at the top there.
Oh, sorry. At, show me, sorry. Oh, 1:10.
And at what time did you arrive?
10 minutes later at 1:20.
Right at
1:30, sorry. Time, 1:37.
Okay, thank you. And are you in agreement that the times that you wrote on the report are different than those you gave in your statement?
Yes.
And while examining the car, you noticed that the front tire was flat, correct?
Correct.
But you never sent this tire to the lab to be tested, did you?
No, because I believe that it was the impact of the curb that did it, not anything else.
But you said it wasn't necessary to test the tire?
Exactly.
But you are aware that testing this tire could have led to a definite conclusion as to the cause for it being flat, correct?
Highly unlikely, but it could have.
But testing the tire would have provided us with more information, right?
It could have, yes.
You interviewed Sydney at the hospital, correct?
Yes, I did.
And was it you who ordered Sydney's blood alcohol test?
Yes.
Your Honor, I'd like to once again approach the witness with her statement.
Any objection?
No, Your Honor.
Go ahead.
Could you please read for me on line 84 there?
Here?
Yep.
The doctor in the ER ordered a blood alcohol test on Sydney Young in order to determine Sydney's perception of pain.
Okay, thank you. So it was not you who ordered
No,
the test?
it was the
correct?
doctor.
And now while at the hospital, you interviewed Sydney, but you said that you think her memory was affected because of the pain medication she was on at the time, correct?
Yes.
And don't you think that it would have been wiser to interview her after the medication had worn off?
I suppose, but I didn't have time.
But if you would have waited to interview her, her memory might not have been as impaired, correct?
Correct.
And you said that Sydney claimed to be wearing a seatbelt?
Yes.
And you also obtained Riley's cell phone records, right?
Mm-hmm. Yes.
And you said that you believe Sydney typed the last message, correct?
Yes.
But you cannot say 100% for sure that Sydney sent that last message, can you?
Not 100%, but the voice of the text message is different than all the other ones.
But you don't know for sure that she sent that, do you?
No.
No further questions, Your Honor.
Redirect.
Now, isn't it true that you're the one who made sure that Sydney Young went to the hospital?
Yes.
So technically, you made sure she got in the right hands to get the blood alcohol test, correct?
Yes.
Objection, Your Honor. Leading question.
Sustained.
Did you or did you not make sure that she got the alcohol test
Yes, I did.
from the hospital?
Yes.
Okay. Now, didn't you also see Sydney before she was sent to the hospital?
Yes, I did at the accident.
And did she look pretty messed up?
Yeah, she looked pretty out of it, and she looked drunk, and
So, your opinion was formed when you saw her at the accident, not when you saw her at the hospital, correct?
correct.
So, would you say that the pain meds were why she was acting weird?
No, I don't think so. I think it was the alcohol in her system.
Objection, Your Honor. It calls for an opinion.
Well, the witness is an expert in accident investigation, and what's your basis for your objection as it relates to opinion? Is it outside her expertise? Is that
Yeah, I believe it is outside her expertise in investigation.
what is your response?
She deals with criminals all the time. She would know what drunkenness is. Isn't that her level of
Well-
investigation?
Lay a foundation for your question. I'll take your objection under advisement at this point.
She's a,
No, I'm not asking you to argue. Ask the witness some questions.
oh, okay. Aren't you a investigator
Yes.
in crimes, correct?
Yes. And DUIs and
So you deal with drunk people all the time.
yes.
So you would know what drunkenness looks like and how the
Excellent.
people respond, correct?
Yes. How they respond when they're drunk.
Objection, Your
Yeah.
Honor. Counsel keeps asking leading questions.
The leading questions are, objection for leading questions is sustained. You have to ask a direct question.
Okay.
Go ahead.
Did you, do you notice other people when they are drunk?
Yes, I do.
And you notice this because,
How they act and how they respond to other people and
okay. Your Honor, I would like to say that she is a investigator, so she would know what drunkenness looks like.
Ask your question.
Thank you, Your Honor.
Okay. You may step down. Your next witness.
Defense would like to call Alex Williams to the stand.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated, please.
Please state your name for the record.
Alex Williams.
Please spell that.
Williams.
What grade are you in?
12th.
What kind of student are you?
About B+ average.
Are you a pretty good student?
Yeah, I would say so.
Were you at the same party as Riley Gardner and Sydney Young the night of the accident?
Yes, I was.
Whose party was it?
It was Austin Kramer's.
You knew what the party was for?
It was some baseball thing.
Was Sydney drunk at this party?
It seemed like she was, yes.
Did you leave the party with her that night?
Yes, her and Riley.
Why did you guys leave the party?
Sydney was pretty drunk and some of us got pretty hungry, so we decided to head over to White Castle.
And Riley suggested that you guys get something to eat.
Yes.
Did you notice something wrong with the car that night?
The tire. It seemed kind of like at the accident I saw that it was flat. I don't know if that was before or after.
When you guys got in the car and started driving, did it seem like Riley was going fast?
No, it didn't.
And any time during that night, did you see Sydney unbuckle her seatbelt?
Yes, I did.
Was it before the accident?
Yeah, it was before.
Did you ever see her rebuckle her seatbelt before the accident occurred?
No, I didn't.
So do you think that maybe her injuries wouldn't be as bad if she had her seatbelt buckled?
If her seatbelt was buckled, I think some of them would have been, they wouldn't even occurred.
Question, Your Honor, she's asking an opinion of the question.
You have a response?
I'm just asking, yes, I am asking for opinion about whether she thinks that Riley was responsible that night.
All right. Objection is sustained unless you lay a proper foundation for an opinion.
Thank you, Your Honor.
Did Riley give the phone to Sydney before the accident?
Yes, he did.
About how long before?
About 10 seconds.
So was Riley texting the cause of the was her texting the cause of the accident?
I would say no.
Objection, Your Honor. Yet again, it calls for an opinion. She's not an expert witness. She can't give her opinion.
Question withdrawn.
Questions withdrawn? Okay.
Thank you.
No further questions.
All right. You may cross-examine.
Miss Williams, do you admit to have brought about 8 beers to the party that night?
Yes.
And from the time range of 11 p.m. to 12:30 a.m., which is an hour and a half, do you admit to taking about 3 or 4 beers?
Yes, I do.
So you two were also intoxicated, correct?
Yes.
And
But I had no plans on driving that night.
but you were still intoxicated, correct?
Yes, I was.
And you witnessed Riley at least sending one text message while driving, correct?
Yes.
And you witnessed Riley and Sydney passing back and forth the phone, correct?
Yeah, Riley threw it at Sydney.
And please just answer like yes or no.
Okay.
And you were in the car, correct, when Riley did lose control?
Yes, I was in the back seat.
Thank you, Your Honor. No further questions.
Redirect.
Yes, Your Honor. You knew you weren't going to be driving that night, correct?
Yes, I did.
And were you responsible enough to make sure that you weren't going to drive that night? You made sure that someone else...
Objection, Your Honor. She's staying leading questions.
I asked, was she responsible enough to...
Reform your question. The
Okay.
question you asked was leading.
Thank you.
Okay. So you made sure that did you make sure you weren't driving that night?
Yes.
Did you receive any injuries from the accident?
No, I did not.
Did you have your seat buckled the whole time?
Yes.
Thank you. No further questions.
All right. You may step down. Another witness?
Defense would like to call Riley Gardner to the stand.
Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated, please.
Can you state your name and spell your last name for the court?
Riley Gardner, Gardner.
Riley, what were you doing on the night of May 11th and into the morning of May 12th?
I was at a party at Austin Kramer's house.
Was alcohol served at this party?
Yes, but I didn't drink any.
How come you didn't drink if everyone else was?
Well, 'cause I've seen the effects of alcohol firsthand because my dad was an alcoholic and I've vowed ever since then not to.
Did you leave the party early?
Yes.
How come you left the party early?
I was feeling uncomfortable around some of the drunk people that were at the party.
Who went with you when you left?
Alex Williams and Sydney Young.
Why did they go with you?
Well, I had suggested that Sydney get something to eat because when my dad was drunk, my mom would have him eat to metabolize the alcohol faster.
Did Miss Young agree to go with you?
Yes, she did.
Did she also agree to let you drive the car?
Yes.
Did you ask Miss Young to buckle her seatbelt?
Yes, I did.
After asking her to do this, what did you do?
I backed out of the driveway.
As you were backing out of the driveway, what happened?
I got a text message from Taylor.
What did it say?
ADNCB now, which means any day now, call back now.
Did you give the phone to Cindy before the accident?
Yes.
Do you believe that this accident was caused by your negligence?
No.
Do you believe that something you had no control over caused this accident?
Yes, I think it might have been the front tire.
Objection, Your Honor. Calls for an opinion.
Do you have a response?
Your Honor, she was in the car that night, and I think she would be able to judge what caused, if her texting was causing the accident.
Well, a witness can testify to facts that they observed or heard or things of that nature, but they can't give an opinion unless you lay a foundation for that opinion. Sustained at this point.
Thank you, Your Honor. Do you believe that the tire had something wrong with it before the accident?
Yes, I do.
Do you believe that that may have been what caused the accident that night?
Yep. Yes.
Thank you. No further questions.
Cross-examination?
You are 18 years old, correct?
Yes.
So you've been driving for a relatively short amount of time, right?
Yes.
2 years, correct?
Yes.
You would say you've had a bit of a lead foot, wouldn't you, ma'am?
Yes.
Isn't it true that in the short amount of time you've had your license, you've already received 2 speeding tickets?
Yes, I have.
Ma'am, you're dating Taylor Bowling, correct?
Yes.
On that of May 12th? Your Honor, I'm trying to show that I need this question to show my further questions' relevance.
All right. I believe it's relevant as to her credibility of her testimony.
Thank you, Your Honor.
Go ahead.
On the night of May 12th, 2008, it was a plan to meet up with Taylor very late that night, correct?
Yes.
So it would be fair to say that Taylor was on your mind that night.
Sort of.
Ma'am, he was driving you crazy, wasn't he?
A little, yeah.
That night you were driving a 2006 Honda Accord, right?
Yes.
However, you weren't too comfortable with that car because you usually drive a Toyota Corolla, don't you?
Yes, I just recently received that car.
A Honda Accord is a lot bigger than a Toyota Corolla, right?
Yes.
Were you having difficulty? You were having difficulty driving it, weren't you?
A little.
Despite being uncomfortable driving this car, you drove at such a speed that it caused you to lose control that night, didn't you?
No.
Well, wouldn't you agree that as a careful, prudent driver, you should drive at such a speed where you have complete control of the vehicle?
I was.
But you lost control of the vehicle that night, didn't you?
I believe it was the tire.
You agree that it's especially important to drive carefully when you're in control of other people's lives, wouldn't you?
Yes.
You drove Sydney that night, correct?
Yes, I did.
Your testimony is that you told her to buckle up, correct?
Yes, I did.
But you didn't check to make sure, did you?
No.
Ma'am, you understand that my client had alcohol in her system that night, correct?
Yes.
You understand that you need to be extra careful and persistent when dealing with drunken people, correct?
Yes.
My client trusted you that night to drive safely. You owed her a duty of care, and you betrayed that by neglecting to make sure that Sydney was safely buckled up, correct?
It was her own responsibility to buckle up.
But as a responsible driver, you were to make sure.
Yes,
correct?
I told her to.
Did you check?
No.
Texting while driving is nothing new for you, correct?
No, I've been known to.
You were receiving text messages from Taylor that night, right?
Yes.
And you read those text messages while driving, correct?
I read one and then tossed the phone to Sydney and asked her to reply.
So as you were operating a vehicle that you weren't comfortable in, you looked down and read a text message, right?
Yeah.
You weren't completely focused on driving them, were you?
Yes, I was. It was 8 simple letters. It's like answering a phone call.
But you looked down and read a text message, didn't you?
Yes.
And your hands weren't in the proper 10 and 2 o'clock position, were they, since you were holding a cell phone?
I suppose not.
So you were not driving with your full attention on the road that night, were you, ma'am?
Guess not.
You don't even know the cause of the accident, do you?
No, I believe it to be the wheel.
You think, but you don't really know.
No.
And you don't know because you weren't paying attention and driving safely that night. You were distracted by Taylor, correct?
Not fully.
No further questions, Your Honor.
Redirect.
Riley, isn't it true? Riley, did you tell people to buckle their seatbelt in the car that night?
Yes.
And weren't you just trying to be responsible by helping Sydney, taking her to get something to eat?
Yes, because I thought it would help her metabolize the alcohol.
Thank you. No further questions.
You may step down. Do you have any further witnesses?
No, Your Honor.
Defense rests? All right. Are you prepared to give your closing argument at this time?
Yes, Your Honor.
You may proceed.
Ladies and gentlemen of the jury, Your Honor, today we have showed you the facts. While defendants clearly don't know their facts, the defendant witnesses have also verbally assaulted our client, cost her her life, and hurt her severely. They say wrongly accused was the witness, but she was only accused of the cold hard facts, that she rocked poor Sydney's life. During that night of the accident, Riley was texting and speeding. Texting, there's an ordinance in there to where it doesn't allow them to text. It's against the law. Riley was being irresponsible and breaking the law that night, while she also had 2 other lives in her hands. She wrecked the dreams of poor Sydney of becoming an artist. Never again will she be able to have that dream. The defendant should be held responsible. She demolished the dreams of a young girl and has incinerated, or has destroyed, she has broken laws. The defendant should be held responsible, giving money to our client, help her go through her life, and have the stuff that she'll never be able to have again. Thank you.
All right.
May it please the court. Ladies and gentlemen of the jury, you should find and will find that Riley Gardner is not liable for any of the claims that Sydney Young has accused. We truly do feel sorry for the injuries that Sydney Young has suffered, but we feel that as a passenger, she has the responsibility to protect herself from the dangers that could be potentially harmful to her. This claim that Riley Gardner caused injury to Sydney is blasphemy. Riley was doing a good deed for Sydney and society. Riley offered to drive Sydney to get food. He could have let her go by herself, but in the condition of her being plastered on alcohol, and Riley not having a drop of alcohol in his system, decided that it was his duty to help out a friend and to protect society from a drunk driver. Now, we have shown you how Sydney Young could have protected herself and prevented these injuries. if Sydney had left her seatbelt on, like instructed by Riley when they departed from the party, we believe that she would have been more capable of reacting to the impact of the accident at hand and would have suffered less injuries. Maybe none. The same goes for the alcohol content in her system. If Sydney had not been intoxicated with a .09 blood alcohol level, she would have been able to handle the accident in a more appropriate manner. As for the accusation that Riley Gardner had been texting before the accident is false. Riley had instructed Sydney to text her boyfriend NTWD, which stands for no texting while driving. And we have Alex Williams, who said on the stand that he saw Riley toss the phone to Sydney and asked her to text NTWD. He had also said that he witnessed Sydney remove her seatbelt while the car was in motion. Now, if Riley had wanted to text while driving, why on earth would he instruct Sydney to text such a ridiculous thing? Thus, according to the phone records and Adrian Knight, there is a clear distinction of two people texting, which can only lead us to believe that the person who was handed the phone before the crash was the one doing the texting. You also heard from Peyton Lancaster, who said that the tire could have been punctured while driving. Could have been. Not sure, could have been. For the final accusation of Riley speeding, you heard from Evan, who couldn't tell a dashboard light from a cell phone light. Now, you can put your trust in Evan, who thinks that he saw the car speeding in a cell phone light, along with Sydney, who was heavily drunk, or you can put your trust in people who know for a fact that Riley wasn't speeding and texting, which is proven by Adrian Knight and Alex Williams. Now, for me, I put my trust in people that I think deserve my trust. Does Sydney deserve your trust? Was she not breaking the law for having her seatbelt off and being drunk while under the age of 21? Or is it Riley, who had instructed everyone in the car to put their seatbelt on and who obeyed the law by not drinking at this party while underage? It is not up to me to make this decision. It is up to you. You should find that Riley Gardner was not liable for Sydney's injuries.
Rebuttal?
We rest your honor.
All right, no rebuttal. All right, that concludes the testimony and evidence in this case. The jury will now retire to the jury room to consider the verdict. So be in recess for 4 minutes.
All rise. Please be seated.
Okay, pardon me. At this time, what we're going to do is have an opportunity to let the judges talk to you about how well you did, and maybe point out some things that hopefully will help you in the future, and point out some things that you did very well, too. So I'm going to start in the back row this time with Mark Davidson.
Obviously, you had opening day jitters, because it's your first round, and that's totally understandable, and we factor that in as we're looking at all of you doing your performances. And I guess sort of the one general comment I'm going to make to the plaintiff's side is you did a very good job on trying to focus on the fact that the defendant caused this accident, but I didn't really hear too much testimony about the pain and the suffering and all these other things. I mean, there was a reference to the injuries, but I think you might have, while you had the poor mangled plaintiff up on the stand, ask her about her life's dreams and how they were hurt. But I mean, that's just one of those things. You have your tactic, and that worked pretty well. Couple technical things. I mean, you want to remember when you're making your opening statement, it is important to point out the burden of proof. I'm pretty sure that was sort of in the outline of the rules. That it's a civil case and it's preponderance of the evidence and that sort of thing, and then and then give us, poor dumb jury. You have a real jury up here. We don't really know anything about this, so it's your job to sort of educate us in advance, and especially in your opening statement, and then wrap that up in the closing statement too. Let's see. The judge may talk to you a little bit about the formalities of getting the evidence in and so forth, so I'm not going to dwell on that. But sort of the other little thing I did notice was sometimes you'd make a very good objection, and the other side would sort of kind of like do the same thing again. Don't give up. If they persist and do it again, just say jump up and object again. Don't think you only have one shot at the objection. The judge will rule, and the judge isn't really supposed to make a ruling until there's an objection. So keep at it. I thought all of you did really good jobs on cross-examination, and as far as being good attack dogs, that's sort of the job there. So good job, and good luck in your future rounds.
Thank you.
Thank you. Thank you.
All right, Mr. Keys.
Thank you. Everybody within this jury box has tried a number of cases, and I think to a person we would all say that when we try a case still, been doing this for 19 years, I still get very nervous before a trial. It's what we go through, and if I wasn't nervous, I would really question myself and think that I really don't care. So it's really a good thing to be nervous before you get up and do your presentation. The most important thing to be, though, is not to give the impression that you are nervous and to be confident in what you're doing. Because one thing that a jury is really looking for is confidence in what you're saying, a true belief in what you're trying to present to your jury. As this went along, everybody started to gain a little confidence. When we started out, you could tell that the confidence level wasn't there, but everybody really started to get it as you went through this. I'm going to use Emily as a good example. When Emily got the cross-examination, as Emily got into it, Emily became a very effective advocate for her client. She started to really nail the objections, and she started to really nail the points that she wanted to make in cross. And at the same time, her opponent was feeling confidence as well and came across as being very confident. For the defense, you came through very clearly. I really liked your presentation. I thought that that was excellent. You knew what you wanted to do. You told me in your opening statement what you wanted to do, and I very much like that. And all of you should be commended because I thought that your questioning was excellent. You spoke up. I could hear you. You asked questions that I knew were going to elicit a good answer. From the plaintiff's standpoint, you did that as well, but you still need to work on that and improve that. You need to speak up, you need to look at your witness, you need to pay less attention to your notes. And that goes for all of you. The less you can pay attention to your notes, the better off you would be. Overall, though, for your first performance, I would say that you all did an excellent job.
Thank you.
Thank you very much.
Ms. Lane?
Well, I'm sure you're all breathing a sigh of relief that this is over now. And I can more than sympathize, I can empathize, because I remember my first trial practice class in law school and the first trial that we had as part of that class. And I did not sleep the night before. So I understand that you probably did not either. Now, just a couple of general comments that I have. I'm sure all the other judges have specific comments. On direct examination, you have the benefit of having a statement that you can basically use to help your witness walk through their testimony. It's important on direct examination to get the most out of your witness. You know what your witness is going to say, and give them the floor. You ask a short question and let them do the testifying. Sometimes, not always, on direct examination, I thought maybe the attorney testified a little too much, and maybe the witness wasn't given enough of a chance to tell his or her story. But it's really important to do that, to remember that on cross-examination. on cross-examination rather, that was direct. On cross-examination, I think all of you did a very, very good job, and you understood what it was to ask a leading question, which many lawyers have difficulty with. So I think that's much to your credit. The only thing that I would add about cross-examination is that most of you knew what you wanted to ask, and that's wonderful. That means you're very, very well prepared. However, some of you spoke a little too quickly, and it was hard for me to hear you. So just take your time. This is not a race. You'll have plenty of time to get the words out of your mouth. And then when you ask a clear question, your witness will be better able to understand it, and you're more likely to get the response that you like. So that's all I have. Thanks.
Thank you.
Mr. Stremmers?
I congratulate you too, because I know how hard it is to prepare for a case. I know you guys put a lot of work into this, and you all did a great job. The first one is the hardest one, so really good job. I thought the witnesses did a good job because you really knew the facts, which is really important. We as lawyers have to prepare our witnesses with, and talk about the facts and get the facts out, and getting those out, you did a good job. The other thing, I thought, for me, cross-examination was really well prepared in this case. I guess I enjoy cross-examination. That's my favorite part. So you got Ashley and Sam and Emily, in your practices, you guys must have really went over that, because I thought you had some really key objections, or on the other part, when you had the objections, worked out very well too. I noticed a couple times Judge Brown, I can't remember who it was, it might have been Sam, objection, argumentative. And the judge didn't even have to blink. Judge Brown said, sustain, because it was very good that you learning those. And those rules of evidence are very difficult to learn. It takes a long time. On the other side, I think, but when you do, if you get frazzled, it's okay. We get frazzled. We have very smart attorneys on the other side trying to frazzle us. Just take a breath, take a step back, think for a second, go back to what you were doing. So if you get a little frazzled, it's okay. We do too. We get frazzled. And I would reiterate what Mr. Keyes said. Try not to read from your notes. Use them as a guideline, but try in the future rounds, try to ask the question directly without having to look down always at your notes constantly. But overall, I thought you guys did a really excellent job. Congratulations.
Thank you very much.
Ms. Armstrong?
Well, it's very clear to me that you all have been working very hard, and you've put a lot of time and effort into it, and I appreciate that very much because it made it very enjoyable to watch. I agree with a lot of what's been said up here. I don't want to repeat things that have been said, but just a couple stylistic things. When you come over to a witness, it's very important to remember there's and I should say, 90% of what I have written down is really good, but that's not going to help you if I talk about that. So I'm going to skip over that, and just a couple things that might help in the future. Remember that we're behind you when you come talk to the witness, and I can't see what you're doing. I'm sure Mr. Keyes couldn't see. If you're talking to the witness, be mindful of whatever courtroom you're in to be to the side of the witness so that the jury can still see, the judge can see. Everybody still needs to see what's going on. And this was kind of commented upon about taking your time. It's not a race, and you really do have plenty of time. I don't think the time issue ever came into play during this round. You know the facts really well. Your witness knows the facts really well. We happen to know it because of this setting, but in real life, a jury doesn't know anything about it. And when you're rushing through the question and the answer is getting rushed through, it's really hard to process that when you haven't heard the information before. So it's very helpful if you just kind of take a breath, slow down. Same thing if something frazzles you, if there's an objection and it's not what you expected. Silence in a courtroom is deafening, it seems like, when everybody's waiting on you because you've got to ask the next question. But it's okay. Take a moment, look at your notes, get back to where you need to be, and get on course, and you'll be fine. And the only other thing kind of on that same note is, again, a lot of you had scripts to keep you where you need to go, and you need to have that direction, those notes. But make sure you're not locked into it, and that you're able to, when you listen to the answers, it's just as important, probably more important than asking the question, is listening to the answer you get. Because sometimes those of you who are doing cross got a really great concession out of the witness, and then you went on to your next question instead of maybe asking a few follow-up questions. I think Riley acknowledged that that texting isn't distracting, it's like answering a phone. And I thought that was a really interesting answer, because answering a phone is distracting. So I was looking for the attorney who's asking questions to follow up on that. So listen to the answers, but you all did a phenomenal job. Some of you have a very relaxed style. I think you're going to get more relaxed as the day goes on. Particularly with this round, we had such a crash and a boom to start with that it kind of distracts everybody, but you can't afford to spend half the round getting comfortable and then coming out of your shell and doing a great job. Make sure you start right off the bat strong and stay strong. Okay? You're welcome.
And I want to echo what all of the judges have talked to you about. I think you all did a very good job. Obviously, you spent a lot of time in preparation. Stylistically, there's always some improvement that anybody can make, even lawyers who've been at it for a long time. And one of the things I want to point out to you is, in a real trial, when the attorney asks to approach the witness to present an exhibit, I probably would not have asked, what purpose do you want to do this for? I would just let you do it and then have the attorney make an objection if it was done improperly. The reason I did it here is because there are rules for the mock trial that don't exist in a real trial. For example, a witness can't read from something. They have to testify from their memory. And so when you're presenting something, if it's to refresh recollection, that really is a violation of the rules. If you're presenting something to impeach the witness, that's permissible. So when I was asking the question, why do you want to go there, I was trying to give an opportunity to the other side to distinguish what the purpose of them approaching the witness was, so that you could make an appropriate objection if you wanted to. Now, a couple of times, it was when you presented something for the time of the accident, for example, the initial question really wasn't necessary to do that, because the witness had already testified to the time. On cross-examination, it was done appropriately because it was for impeachment, and the witness's recollection in the witness stand was different than what was on the report, so that would have been appropriate. Be careful with leading questions. If the person's your witness, it's real easy to ask a leading question, because you know what you want to get out of the witness. So you can say, "Isn't it true that you did this?" But if you're calling the witness, you have to ask a direct question. So there were a significant amount of leading questions here that could have been objected to by the other side. So be aware of that. I know there was some objections for leading questions, and I forget which judge mentioned this, but it might have been you, Emily. You objected to a leading question, and then Henry asked another leading question, and you didn't object the next time. So it's right after, I ruled, I sustained your objection, but then he just asked another leading question, and you could have stood right back up and said, "Judge, you just ruled you can't do that." So, but, if you can get away with it, fine. That's the whole thing. If there's no objection, I'm not going to make a ruling on it. Also, point out a couple of things. On Riley Gardner, for example, I thought maybe in cross-examination somebody might have asked about his statement that he texted and then tossed the phone to Sydney, and the accident happened right after that. Well, if you look at the text messages, there's a minute and a half between when he texted that "no text while driving" and the last text. That's 90 seconds. That's a long time. So you might have hit that a little bit. If it happened if you get him to admit that it happened right after, that the accident happened right after he tossed the phone, and then you hit him with, well, it's 90 seconds between that time and the last, he can't back away from it. He can't say, well, yeah, it must have been there, because he's already made the statement, yeah, I tossed it right after that. So take a look at the particulars of their statements in doing your cross-examination. In cross-examining Alex Williams, for example, he says, "I was buckled in, but I have no ideas if the others were, because I'm not the seatbelt police." But then next in his statement, he specifically says he wasn't buckled in. So you can't have it both ways. I thought maybe somebody might have hit that a little bit on that as well as the fact that he had been drinking himself was ripe for impaired recollection. You know, you've been drinking, so you really don't know what was going on there. And you could have hit that a little bit more too. But all of you did a very good job with what you did, and I agree with the others. The time is not a problem here, so don't race. Present your case. You know this case better than anybody because you prepared for it. If you rely too heavily on notes and you lose your place in a note, you get flustered. So it's kind of nice to go from you're prepared here. You're going to stand up there and just bang it home to the jury and let them know what you're advocating for. And I think you did a nice job overall. I think everybody did a very good job, and I'm very pleased with the effort you put in this. And I wish you very well in the future rounds. The witnesses, you have the toughest job, I think, because you don't get any notes. You know, you have to remember everything. Everybody else has something sitting in front of them they can go from. So you all did good. Congratulations to you and good luck.